The Penal Code addresses the issue of jurisdiction. While jurisdiction may seem a simple concept, there are a few unusual situations the Penal Code addresses in order to assert its ability to prosecute. We will discuss both the simple and the unusual in this screencast. First, the simple. Texas has jurisdiction over an offense if the conduct or the result that is an element of the offense happens in Texas, or the conduct outside of Texas constitutes an attempt to commit an offense inside Texas. For instance, if you buy a gun in North Dakota and then travel into Texas with the intent to commit murder, but are caught before you can actually kill someone, Texas can still prosecute you for attempted murder, even though your overt act took place outside of the state. Next, the Penal Code states Texas has jurisdiction over an offense if the conduct outside of Texas constitutes a conspiracy to commit an offense inside of Texas, and an act in furtherance of the conspiracy occurs inside of Texas. For example, if you conspire outside of Texas to kill a person inside of Texas, enter Texas and buy a gun for this purpose, but are stopped before the killing, Texas may still claim jurisdiction, even if the conspiracy started or was confined out of state. The Penal Code continues that Texas has jurisdiction over an offense if the conduct inside of Texas constitutes an attempt, solicitation, or conspiracy to commit a crime. These are called in-show offenses. It continues that Texas has jurisdiction over an offense if it establishes criminal responsibility for the commission of an offense in another jurisdiction that is also an offense in Texas. For instance, let's say two people conspire in Texas to kill someone in Virginia and buy a gun in Texas for this purpose, but they are stopped before they ever leave the state. Texas may still claim jurisdiction even though they intended for the killing to take place outside of Texas and charge them under Texas law with conspiracy to commit murder. Sometimes it is difficult to establish precisely where a criminal homicide was committed, particularly if a body is dumped somewhere other than the place where the killing occurred. In this case, the Penal Code states that if the body of a criminal homicide victim is found in Texas, it is presumed that the death occurred in Texas. Related to this, the Penal Code states that if death alone is the basis for jurisdiction, it is a defense to the exercise of jurisdiction that conduct is not criminal in the jurisdiction where it occurred. For example, let's say a body is found here in Texas, and the fact that it's found here is the only basis for jurisdiction. But it's determined the manner in which the death was caused occurred in Mexico, where the specific act which resulted in the death is not an offense. In a case like this, the defendant might be protected from prosecution on the basis that Texas doesn't have jurisdiction. Keep in mind, this scenario would be very unusual and is highly unlikely. The Penal Code addresses another rare possibility. It states an offense based on an omission to perform a duty imposed on an actor by Texas law is committed inside the state regardless of the location of the actor at the time of the offense. So for example, let's say a nursing home company headquartered out of state shuts down an in-state facility. In doing so, they fail to take several actions the Penal Code requires them to take pertaining to notifying the state, and residents suffer bodily injury as a result. Even though the persons responsible are physically out of state, the Penal Code asserts jurisdiction to prosecute them for their omissions that occurred out of state. Finally, in regards to jurisdiction, the Penal Code states Texas includes the land, water, and airspace above the land and water over which the state has power to define offenses. lots of acts that are illegal and lots of things it's illegal to possess. On the other hand, there's only a few actions a person is required to do by the Penal Code and can be criminally penalized for not doing. Remember, the elements of an offense include the forbidden conduct, the required culpability, the required result, and the negation of any exception to the offense. In this screencast, we'll discuss how the Penal Code characterizes prohibited conduct and specifically addresses possession. The Penal Code states, a person commits an offense only if he voluntarily engages in conduct, including an act, omission, or possession. Remember, an omission is a failure to act. Voluntary possession can be problematic because a person who's caught with something they're not supposed to have will frequently say, hey, that's not mine. Since we can't read minds and we can't always trust words, the Penal Code infers from the situation when possession of something is considered voluntary. The Penal Code states, possession is voluntary if the actor knowingly obtains the thing possessed, or receives the thing possessed, or is aware of his control of the thing for sufficient time to permit termination of control. So just because you don't have the drugs in your pocket doesn't mean you don't own them. Your possession of the drugs is considered voluntary if you have them in your glove box or even in the shed of your backyard. You are aware of them, or at least a reasonable person would have been aware of them, and you had sufficient time to seize control of them. Finally, the Penal Code states an omission is not an offense unless a law indicates specifically that the actor has a duty to act. So in order to commit a crime by omission, the Penal Code must state you had a specific responsibility to do something, and you did not do it. An important aspect of our law is that we believe it's not fair to hold someone accountable for an offense that isn't written down. This could also lead to government abuses. Criminal law is written to be very specific. At the same time, we realize there's bound to be some situations that arise that technically meet the elements of the offense, but that we view as justified and therefore shouldn't be criminal. For this reason, many penal code statutes include specific defenses that allow for some degree of common sense to be inserted. Think of conduct in terms of what is not prohibited, what is prohibited, and the gray area that falls in between. The range of the conduct continuum identifies the range of actions or omissions the written law addresses. In general, the law may specifically mention actions that are not prohibited, or if it doesn't mention them, it's an indicator they are not prohibited. For instance, kicking the back of an airplane seat is not mentioned, so it's not prohibited. The law also specifically mentions actions that are prohibited. For instance, robbing someone with a gun is definitely mentioned in the penal code. Let's look at a more specific example. The age of consent for sexual activity in Texas is 17. A 14-year-old having sex with a 16-year-old is not addressed in the penal code and therefore not prohibited. A 21-year-old having sex with a 16-year-old is prohibited by the statute. An 18-year-old having sex with a 16-year-old is identified as a gray area and addressed with a defense in the statute. An 18-year-old boyfriend having consensual sex with his 16-year-old girlfriend is typically viewed much differently than a 40-year-old having sex with a 16-year-old, and the penal code recognizes that. The defenses in the penal code allow us to hold persons accountable by being very specific with the written law, yet acknowledging there might be some circumstances that are less offensive to community standards. The penal code categorizes 3 different types of gray areas and identifies how each will be resolved. Just as a note, we are speaking about Texas specifically. What we discuss here will likely be different than what might be described in criminal law textbooks, which are written in very general terms. The Texas Penal Code identifies exceptions, defenses, and affirmative defenses that could all be included in specific statutes. Individual penal code offenses may indicate all, some, or none of these categories of defenses in a statute. If they do, they will specify the requirements for that specific offense. Understanding each category is important because the category of defense indicates which side, either the defense or the prosecution, has the burden of proof. First, the penal code identifies exceptions. These are phrased as, it is an exception to the application of. The burden of proof is on the prosecutor to prove the conduct did not fall within any exceptions to prosecution within the specific statute. The defendant would pose his act or omission fell within the gray area of the statute and therefore was not prohibited. The prosecutor must prove it did not. For example, the penal code offense of abandoning or endangering a child states it is an exception to the application of the offense if a parent or guardian voluntarily delivered a child to a designated emergency infant care provider. So a defendant in a case like this, in order to use this exception, would have to pose at trial that he dropped the child off in question at an emergency infant care provider. The prosecutor would have to prove otherwise, and if the prosecution could not do this, the defendant would have to be found not guilty. The next category is defenses. These are written as, it is a defense to prosecution. The burden of proof is on the prosecutor to prove the conduct did not fall within any circumstances when the conduct would be justified. The defendant would pose his act or omission was not prohibited under the statute. The prosecutor must prove it was. For instance, let's say our 18-year-old is a hospital technician who is charged with sexual assault of a 16-year-old for fondling her while she's a patient. The statute indicates that his conduct may be excused if it was part of legitimate medical care. If the defendant wanted to use this defense, he would have to pose his acts were part of medical care, and the prosecutor would have to prove they were not. If for some reason the prosecutor could not prove that his acts were not part of medical care, the defendant would have to be found not guilty. Finally, affirmative defenses. These are phrased as, it is an affirmative defense to prosecution. The burden of proof is on the defense to prove the conduct which would have otherwise been criminal was not criminal under the particular circumstances. The prosecutor would pose the act or omission was prohibited. The defendant must prove it was not. Let's say our 18-year-old is charged with sexual assault for having intercourse with his 16-year-old girlfriend during a consensual encounter. There is an affirmative defense available to him that states his conduct may be excused if there was less than 3 years age difference between the two. This is commonly called the Romeo and Juliet defense. The 18-year-old defendant must prove there was less than 3 years difference between the two. If the defendant was able to do that, he would have to be found not guilty. Presumptions are sort of legal shortcuts in the penal code. We'll discuss them in this screencast. The best way to explain a presumption in the penal code is through an example. Penal Code Section 32.51 is the offense of fraudulent use or possession of identifying information, commonly known as identity theft. Section B-1 indicates a defendant is presumed to have intent to harm or defraud another if they possess at least 3 separate identities without consent. At trial, a prosecutor is required to prove each element of an offense. An intent to harm or defraud in this situation is one of the elements of the offense. If the prosecutor doesn't prove each element of the offense, the jury, if they are following their instructions, are required to find the defendant not guilty. In Texas, a presumption is sort of a shortcut. If a defendant were found to be in possession of 1 or 2 separate identities, the prosecutor would be required to prove the defendant had intent to harm or defraud. But the Penal Code states that a defendant who possesses 3 or more separate identities is presumed to have intent to harm or defraud. Because of this, the prosecutor does not have to prove the intent to harm or defraud. It is already presumed. Individual penal code offenses may contain several or no presumptions. If indicated, the statute will specifically describe what the presumption entails. The Penal Code defines some ground rules for how culpable mental states are included in offenses and clarifies that certain acts can still be considered criminal even if the defendant didn't mean for the result to occur. The Penal Code states, a person does not commit an offense unless they have the required culpable mental state connected with the offense as required by statute. Again, though, a specific statute may indicate no mental state is required, and if a mental state is not indicated in a statute, the mental states of intentionally, knowingly, or recklessly suffices. The Penal Code also mandates an offense defined by municipal ordinance or county commissioner's ordinance must include a culpable mental state. The Penal Code further clarifies that proof of a higher degree of culpability than required satisfies the elements of the offense. For example, if a person is being prosecuted for an offense where the culpable mental state is recklessly, then they will be found guilty if the prosecutor can prove they committed the offense either intentionally, knowingly, or recklessly, but not negligently. Finally, the Penal Code states a person is considered criminally responsible if the result would not have occurred but for their conduct. For example, a motorcyclist goes 120 miles per hour down the highway and crashes and kills his passenger. Did he mean for it to happen? No, of course not. But the result would not have occurred but for his conduct. In other words, him going 120 miles per hour down the highway. So the driver can be held criminally responsible. How often have you made a mistake about the facts of a situation? In this screencast, we'll discuss the Texas Penal Code defense of mistake of fact. Make sure you take note, though. Your mistakes made in good faith might be a defense, but your assumptions aren't. The Penal Code states, it is a defense to prosecution the actor, through mistake, formed a reasonable belief about a matter of fact that negated the culpability required. So, mistake of fact is when a person violates a law due to a good faith mistake. An example is selling alcohol to a minor. Let's say the minor produced a fake driver's license to a bartender that looked legitimate, and a reasonable person could have made the same mistake. In this case, the bartender might be able to offer a mistake of fact defense. Of course, if the license didn't appear legitimate, then this probably is not going to work. If the bartender hadn't asked for any proof of age at all and simply assumed the person was the legal drinking age, then there can't be a mistake of fact. Mistake of fact involves a good faith mistake, not simply an assumption. Finally, the Penal Code clarifies that even if the mistake of fact is valid, the actor may still be convicted of an offense as applied under the facts he or she believed existed at the time. Do you know every Texas law? Of course you don't. The next offense we'll discuss is referred to in the Texas Penal Code as mistake of law. Mistake of law occurs when the defendant does not know a law exists. Only in rare cases is it a legitimate defense, and, similar to mistake of fact, it can't be based on simply a lack of knowledge. The Penal Code states, mistake of law is an affirmative defense if the actor was ignorant of the law because he or she relied upon an official written statement of the law, such as an official printed copy of statutory law, or the actor relied upon an official written interpretation of the law of a court, such as the official printed copy of a court's opinion in a case. So the common phrase is, ignorance of the law is no excuse. Maybe it would be better phrased as, ignorance of the law is unlikely to be an excuse, since a defendant wouldn't be able to claim mistake of law without it being based on their interpretation of an official written document that contained errors. Even if this defense is successful, the Penal Code states the actor may still be convicted of an offense as applied under the law the actor believed existed at the time. The entrapment defense is one of my personal favorites because it's so incredibly misunderstood. It's the next Texas Penal Code defense we'll discuss. According to the Penal Code, it is a defense to prosecution the actor was encouraged or enticed by agents of the state, usually the police, to engage in an act he or she would not otherwise have committed. Would not otherwise have committed is an important distinction. The key to entrapment is the predisposition to engage in the criminal conduct, and to an extent the actions of the police, which shouldn't be extraordinary. The question to be posed is, would the person have engaged in the criminal conduct anyway, even without government encouragement or enticement? For instance, you've probably gotten a speeding ticket at some point in your life. You may have even been caught in a speed trap, as many like to say. But there is an important distinction between a trap and entrapment, having to do with the predisposition to commit a certain crime. For instance, how many times in your life have you been speeding and not been caught? How many times prior to your ticket had you been speeding on the exact same road and around the same time you got your ticket? It just so happens on that particular day, there's a police officer there running radar and he catches you. He didn't trick you into speeding. You are already doing it or predisposed to doing it. True entrapment involves crime that a person is not predisposed to do, and potentially extraordinary actions of the government. For instance, let's say you are walking down the sidewalk when a police officer on the other side of the street says, "Come here." You cross the street, and then he writes you a ticket for jaywalking. This would probably be considered entrapment. Were you predisposed to jaywalk? No, probably not. Was the officer's act of summoning you just to write you a ticket extraordinary? Probably so. You only jaywalked because you were following the directions of the officer, as most good law-abiding citizens would do. Television and the movies has gotten us used to the term accomplice, or someone who helps another commit a crime. In Texas, we can use the term accomplice informally, but Texas law makes no distinction between the criminal responsibility of someone who commits a crime and a person who merely helps him or her. They both share equal responsibility under Texas law. According to the Penal Code, a person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible, or by both. For instance, let's say two men go to rob a store. One goes inside with a gun while the other waits outside in the getaway car. While inside, something goes wrong and the first man ends up killing the store clerk. The second robber, even though he is outside in the car and didn't even touch the gun, is considered just as criminally responsible under Texas law for the death as the robber who was inside and pulled the trigger. This is sometimes referred to as law of parties. The Penal Code states each party to an offense may be charged with commission of an offense. Again, the Texas Penal Code does not distinguish between actors and accomplices. In our example, both men would be charged with capital murder and could both face capital punishment. Now, it's important to note that the prosecutor might very well seek different punishments for the two robbers since their role in the death was different, but under the law, they are the same. The Penal Code continues to identify situations where one person might be considered responsible for the conduct of another. It states, a person is criminally responsible for an offense committed by the conduct of another if, acting with the culpable mental state required for the offense, he or she causes or aids an innocent person to engage in conduct that is prohibited, or helping or assisting in the commission of offense, that person solicits, encourages, directs, aids, or attempts to aid another person to commit it, or having a legal duty to prevent the offense and acting with intent to promote or assist its commission, he fails to make a reasonable effort to prevent it. Some examples of these could include a competent adult encouraging, directing, or aiding someone who wouldn't be considered competent under the law to make decisions to commit a crime, such as a child, or a mentally disabled person. Another example could be a competent adult forcing someone else to commit a crime, or a person who had a duty specifically written in the Penal Code to stop someone else from committing a crime and didn't stop them, such as a caregiver with a statutory duty to act or report child abuse or neglect who was able to and didn't. These statutes essentially prevent a person who had a significant role in a crime but who didn't actually commit the crime from saying, "Hey, you can't charge me, I didn't commit it." The government can still hold them responsible under the law of parties. The Penal Code attempts to close any loopholes or wiggle room for accomplices by stating, it is no defense to prosecution, the actor belongs to a class of persons that by definition of the offense is legally incapable of committing the offense in an individual capacity. So, for example, a class of people not legally capable of committing an offense are juveniles. Let's say an adult conspires or makes a plan with several other persons who are juveniles under the law to rob a store. They talk about it and even take overt acts such as buying a gun in order to rob the store. They are caught before they can rob the store, though, and the adult is charged with conspiracy to commit aggravated robbery. The juveniles, on the other hand, are referred to juvenile court for their delinquency, since they can't be charged under adult law. Well, in order for this charge to be valid, there must be more than one person involved in the conspiracy. So the adult argues some of his fellow robbers are juveniles and can't be charged with conspiracy under adult law. Therefore, there is no conspiracy. The law closes this loophole by saying it is still a conspiracy to commit aggravated robbery, or any other crime for that matter, even if you enter into a conspiracy with some people who could not technically be charged with the crime, such as juveniles. The Penal Code continues to state, it is no defense to prosecution. Another person who participated in the offense was not prosecuted, or Another person who participated in the offense was found not guilty. The final in-show offense in the Texas Penal Code is a variation of criminal solicitation. The law goes out of its way to protect juveniles from harm, and so it goes out of its way to define criminal solicitation of a minor by an adult. Now, don't confuse this offense with the sexually oriented offense of online solicitation of a minor. This is the in-show offense of criminal solicitation of a minor. It states, an adult who, with intent to commit murder, capital murder, indecency with a child, aggravated kidnapping, aggravated sexual assault, aggravated robbery, a violation of Health and Safety Code Section 481, sexual assault, a felony of the first degree injury to a child, sexual performance by a child, a felony of the first degree criminal solicitation, compelling prostitution, or finally, trafficking of persons who requests, commands, or attempts to induce a minor to engage in conduct that would make that minor commit or be a party to the offense, then that actor commits the offense of criminal solicitation of a minor. Just like criminal solicitation, a person may not be convicted under this section on the uncorroborated testimony of the person allegedly solicited except under very certain circumstances. The main difference is that while criminal solicitation applies only to capital felonies and felonies of the first degree, criminal solicitation of a minor may be applied to several other criminal offenses, not all of which are capital felonies or felonies of the first degree. There are also differences in punishments, as we'll see here in a moment. The Penal Code states it is no defense to criminal solicitation of a minor. The minor solicited is not criminally responsible for the offense. The minor who was solicited has been acquitted, not prosecuted, convicted of a different offense, or is immune from prosecution. That the actor belongs to a class of persons that by definition of the offense is legally incapable of committing the offense, or that the solicited offense was actually committed. The penalties for criminal solicitation of a minor are: if the actor was 17 and in a gang, then the penalty for solicitation of a minor is the same level as the solicited offense. If the offense was part of gang activity, then the penalty is the same level as the solicited offense. And finally, for all other offenses, the penalty is one level lower than the solicited offense. The law recognizes that sometimes human beings figure out what they're about to do is a really bad idea. It takes into account that a person who attempts a criminal act, conspires to commit a criminal act, or solicits another to do a criminal act may have a change of heart, and this should be taken into consideration in the punishment phase of a trial. In this screencast, we'll discuss the renunciation defense. The renunciation defense applies specifically to in-show offenses. It states it is an affirmative defense, which means the burden of proof is on the defendant, that the offense was not committed because the actor abandoned criminal conduct and the actor took additional measures to prevent it from happening if abandoning the offense alone was insufficient to keep it from happening. It is also an affirmative defense to conspiracy or solicitation that the actor voluntarily and completely made renunciation of his criminal objective by countermanding or purposely withdrawing his solicitation or withdrawing from the conspiracy before the offense was committed and took additional measures to prevent it from happening. So you can't just not show up on the day you've conspired with another person to kidnap your boss. You have to take active measures, such as calling your co-conspirator and saying, I don't want to do this anymore, and we shouldn't do this anymore. And if they're going to do it anyway without you, calling the police and reporting them. Of course, it would be really convenient for criminals if every time they got caught and charged with attempting conspiracy or soliciting an offense to defend themselves by saying, hey, I was going to stop, or I was going to tell them not to do it. To close this loophole, the Penal Code establishes that renunciation is not considered voluntary if it is motivated in whole or in part because the actor realized he or she would be caught, or decided to postpone the activity or change the nature of the activity. Now, just because you renounce the activity doesn't mean you're off the hook from criminal charges. The Penal Code states, evidence the actor renounced the criminal activity by abandoning the criminal conduct, countermanding the solicitation, or withdrawing from the conspiracy before the offense was committed, and took measures to prevent it, shall be admissible as mitigation at the hearing during a punishment phase. So, you don't just get a free pass because you renounced criminal activity, but we'll take it into consideration when assessing your punishment. A final note of clarification as we close our discussion on in-show offenses. The Penal Code sets constraints in order to prevent vague or unfair charges. It states, attempt or conspiracy to commit or solicitation of a preparatory offense defined in the in-show chapter is not an offense. In other words, you can't have charges with two in-show offenses joined together. There can't be charges such as conspiracy to commit attempted murder or solicitation to conspire to commit murder.